Welcome back to Between Nine Chairs. Today my guest is Mr. Clarence Thomas, the second African American appointed to the Supreme Court in 1991 by George H.W. Bush. My first question for you, Mr. Thomas, is what is your educational background and upbringing?
Yep. So I first went to College of Holy Cross and I wanted to become a priest, but I felt that the Catholic Church wasn't doing enough to combat racism, especially in the 50s and 60s, and it kept persisting through Jim Crow laws until ultimately the Supreme Court passed Brown v. Board of Ed. But I wanted to make a difference, and I felt the Catholic Church wouldn't provide me that, so I went to Yale Law School.
What was your path in terms of jobs to get to the highest court in America?
Yeah, so I spent 8 years as at the Court of Appeals, Circuit Court, and then under Bush, I was appointed to the Equal Opportunity Commission, and from there to the U.S. Supreme Court.
What is your form of interpreting the Constitution? How do you interpret the Constitution?
Yeah, so I'm an originalist, but rather than being a living constitutionalist or like seeing in the eyes of the framers or in the eyes of the states as it was ratified or looking strictly at the words, I try to find combinations, but so if like 2 of the 3 agree on one idea of the framing, that's the framing I'll use. So I try to find interlapping between all the different approaches to originalist thinking.
Is there any reasons or instances or parts of your life that would make you think that way? Some things you were raised and were taught that would lead you to think about these kind of, or interpret the Constitution that way?
Yeah, I mean, even on the issue of slavery, as it's mentioned in the Constitution, all men are created equal, but that may have not been interpreted at the time to mean slavery. But I feel like if you take the view of what the Constitution says in that situation, it's more beneficial to society as a whole, especially as seen in Brown v. Board of Ed.
You openly spoke out against the decision of Tinker versus Des Moines. What was your reasoning behind that speech, and do you think that will carry over or be present in your decision in our character case?
Mm-hmm. So yeah, on Tinker v. Des Moines, I felt that once a student enters a school, the school is the one that's supposed to provide order and make sure things don't get out of hand. So any sort of speech that will disrupt order, even in Tinker v. Des Moines, the black armband, it could be distracting. I feel like it's the school that has the right to and has jurisdiction over that, not the courts. And then even following the president of Tinker v. Des Moines, I feel like in this specific case, the disruption that was caused was so apparent with students walking out that I feel like you can't ignore the disruption that was caused directly as an act of the speech, even though it was nonviolent.
Thank you.